I'd like to call to order this evening the June meeting of the New Bern Board of Adjustments. Seth, would you call the roll, please?
Yes, sir, Mr. Chairman. Richard Parsons, Dorothea White,
Here.
Peter Dillon,
Here.
Jim Morrison,
Here.
John Riggs,
Here.
John Murrell, Kip Paragoy,
Here.
Barbara Sampson,
Here.
Jonathan Foster, Ross Beebe.
Here.
Thank you, we have a quorum.
Okay. First order of business this evening is the minutes from our last meeting on May 18th. They've been circulated. Anyone have comments, thoughts, corrections that need to be made before we enter these minutes into the permanent record?
Barring any corrections, I make a motion that the minutes be approved as received.
Thank you.
Second.
We have a motion and a second. Any further discussion? If not, please signify your approval of the minutes of the May 18th meeting by signifying by saying aye.
Aye.
Aye. Opposed? Minutes are approved. Okay, this evening we are taking up some old business. As you recall, and as stated in the minutes of the May meeting, we are going to resume the hearing on the request for a special use permit for a solar farm on Highway 55 west of New Bern. This is a continuation of the meeting, and I think since that was a month ago, I think we'll kind of start all over again at the very beginning and go through our normal process so that it is on record that we've touched all bases in this process. So, with that in mind, I'd like to also state for those in the audience, kind of go over what we're going to be doing this evening so that you'll feel comfortable with the process as it unfolds this evening. The Board of Adjustment is a quasi-judicial board. Consequently, everyone who wishes to speak at tonight's hearing must be sworn in before speaking. The second important aspect of being a quasi-judicial board is that we may only consider substantial and material evidence, in other words, facts, in our decision-making process. We cannot accept hearsay, opinion, or emotions. The first step in the hearing process is for the application for the special use permit to be presented to the board by the city staff. Following the staff presentation, the board will begin to solicit facts concerning 6 requirements specified by law. After each of the 6 requirements, there will be a public comment period where evidence will be presented to the board. After all 6 items have been presented, evidence heard, and closing comments made, the board will deliberate and vote on each of the requirements, one at a time. Following the voting, the board will vote whether to approve or deny this application. So the next step in this process would be the swearing in of anyone who wishes to speak to the board this evening. So if you wish to speak, please step forward to the podium. Okay. And again, as we stated, this is a continuation of our May 18th meeting, which was a public hearing on special use permit request for a utility facility, solar farm. Property is located at 757 North NC Highway 55 West and is further identified as Craven County Parcel Identification Number 8-218-010, 8-218-011, and 8-218-015. Seth, would you introduce the request from the staff's perspective?
Thank you, Mr. Chairman. And real quick, we had a few questions at the beginning of the last meeting with regards to completion. Do you want me to address that now, Kip, or what was that?
I think when we get to the first step about the application being complete, we can deal with that then.
Very good. Okay. So again, Plot Hound Solar LLC is our applicant. We just want to give them an extra special thanks. They've been, due to the coronavirus, we've had to put this meeting off for several months. We just appreciate them working with us and coming in here today to get this hearing over with finally. So the location of the proposed project is 757 North NC Highway 55 West. The property is currently zoned A5 and R20. And the request is for a solar farm utility facility. And the proposed development is approximately 30 acres. Currently, the land is in agricultural use. You see the outline of the property here in yellow. We've got the site plan submitted by the applicant. See section 15-146, the table of permissible uses. Utility facilities in the neighborhood or community and regional both require special use permit. And the property was posted per the ordinance. Again, according to the table of uses, community and regional utility facilities must obtain a special use permit in any zoning district to operate. Staff finds the application has met all the land use ordinance requirements of section 15-54 for a special use permit. We have no objection to approval of this request.
Okay, thank you.
Thank you.
At this time, if the applicant would like to present to the board your views of the application and what you're planning on doing, we'd be glad to hear from you.
Mr. Chairman, ladies and gentlemen of the board, my name is Colin Tarrant. I'm an attorney with Black, Crouch & Keeter in Wilmington. I'm here on behalf of the applicant, Plot Hound Solar. As staff has stated, this is our application for a special use permit to operate a solar farm currently located in the A5 and in the R20 zoning districts in the city of New Bern. I think the proposed project will encompass approximately 30 acres. Accompanying the special use permit application was a package from the applicant that consisted of quite a bit of information that I'm sure you've had a chance to either review prior to this hearing or you have before you right now. In that packet is going to consist of a project overview statement as well as an affidavit from Mr. Chris Sandifer, who's with us here tonight. Mr. Sandifer is a North Carolina professional engineer. He would be available to answer any questions you may have regarding the operation of the solar farm itself. As I said, he has quite a bit of experience dealing with solar farms and will be able to go into the details of the operations as well as some of the more technical aspects of the solar farm. There's also a site plan, a ground lease and easement agreement which explains the relationship between the proposed operator or developer of the project as well as the property owners themselves. I know there was some questions as to how those relationships developed and will be represented. Those are illustrated by the documents that are included in that packet, such as that ground lease and easement agreement. There's also a purchase and sale agreement for a proposed sale of the land that would be used for the proposed solar farm. There's some certifications from the North Carolina Utilities Commission and certificates of public convenience and necessity. And there's a solar impact study that's been prepared by Rich Kirkland. Mr. Kirkland is here tonight as well. He's removing or replacing the sign-in sheet. But Mr. Kirkland is an MAI appraiser. He's proposed or he's put together a report that you should have in your packet that will address the findings regarding the valuation of the property and how there will not be a negative effect to the property values as a result of the development of the solar farm. We maintain that based on the information that's been provided you in your packet, that this application meets the criteria that's set out in the City of New Bern ordinance, specifically in section 1554, and as well as the requirements that are set out in the North Carolina general statutes, specifically that there is enough competent material and substantial evidence provided to you in the packet, as well as what we'll be able to provide you here tonight as far as questions and additional information to base as, an approval that we're requesting of our permit here this evening. At this time, I'd like to introduce Christine Valcourt. Christine Valcourt is with Gringo Energy. She'll be able to give you a lot more information as far as the ins and outs of the project itself and walk you through not only how we meet each of the criteria set out in the ordinance, but also to address any other questions you have regarding the actual development itself.
Thank you very much.
Good evening to the board. Thank you for having us here tonight. I'm Christine Valcourt, and I'm a developer with Gringo Energy. And Gringo Energy is the developer for the Plothound Solar Project. Just a brief, I guess, overview of the project. What we have proposed here is a 5 megawatt solar project, which is a fairly typical size here in North Carolina. It will be a single axis tracking solar farm, so that means the panels will track east and west with the sun. At a high level, the solar farm will be connected to the Duke Energy Progress grid, so it'll serve the existing grid, and we'll be selling our power to Duke Energy. So that's how that relationship works. The project has already completed the study with Duke Energy. So in North Carolina, projects that are interconnected to the grid must undergo a study process with the utility. So I'm happy to report that we've successfully completed that and made the interconnect deposit on behalf of the project. So what that means is that the commitment's been made, and Duke, I believe, has actually already started the work on their side out at the site. So we believe our package and the site plans meet the requirements in the ordinance, specifically in section 17-53. The project will meet the setback and screening requirements for the respective zoning districts of A5 and R20, which are 35 feet in the front, 20 feet on the sides and the rear. And the applicant will adhere to all the screening requirements in section 15-364. And so that was a type A buffer. And what we are contemplating is a mixture of existing and then planted vegetation, which we've demonstrated on the site plan. Are there any questions about the project?
I think they'll probably evolve as we get through the six-step process, and
Okay.
the board will be able to ask you questions and during that process. And you'll have more time to come forward and respond to each of those 6 questions as they are presented.
And I think, kind of piggybacking off what Colin said, this will be a combined lease/purchase. So we are leasing 2 of the properties here that are owned by the Dillahunt Williams LLC. Mr. John Dillahunt is here tonight. He is a manager of the Dillahunt Williams LLC. And then we are looking to purchase the 3rd parcel owned by the Tyler family.
Okay, thank you very much.
Thank you.
Okay, at this time, I'm sorry, go ahead.
If I could, Mr. Chairman, I apologize. As I went through the application package, I don't think I specifically or formally requested that application package be entered into the record. If I could at this time, just formally request that to the extent that it's required, that package of information that was provided with the application is entered into the record, if I may do so.
Okay.
Thank you.
So noted. You do have all that, right, Seth?
Yes, sir.
Okay, so it will be part of the package. Okay, at this time, I'd like to begin the process of reviewing the 6-step requirement of the special use permit as set forth. And everyone will have time to talk about it. The first requirement is that the requested permit is within this jurisdiction according to the table of permissible uses. I think it's been established by Seth and by the applicant that that has happened. Is there anyone who would like to speak in favor of or opposed to that requirement that the application is within jurisdiction according to the table of permissible uses? If so, you're welcome to come forth and make a presentation to the board. Hearing no one or seeing no one come forth, we'll move on to number 2. The application is complete. I'd like to go into a little more detail since this was a problem at our last meeting about the application being complete, since at that time it was not clear to us about Mr. Tyler's property. And you have submitted more information to all of us, but I think for clarity, we'd like to clear up the questions that are in the minutes of the 18th meeting.
Yeah, absolutely. I'm happy to take, I guess, the specific question.
At that time, the application did not have any, was not signed by Mr. Tyler, the owner of a piece of the property that was included in the application, and we had no understanding of Mr. Dillahunt's authority to sign as a manager of the LLC.
Sure.
And so those things were of question, and we would like to get them clarified this evening.
Absolutely. So to the first question, the property owned by the Tylers is currently under contract with Plothound Solar. So Plothound Solar will be purchasing the property owned by the Tylers. And so this is, it's a standard North Carolina purchase and sale agreement. It's a T-12 form. So within that contract, that gives us the rights to perform certain amounts of diligence. That includes applying for permits on behalf of the property. So I think in our application package, and then I did provide today again to Seth, was a copy of that contract. As to your second question, the other 2 properties in question are owned by the Dillahunt Williams LLC. And Mr. Dillahunt is here tonight. He is the manager of the LLC, and I believe I provided to Seth today the articles of organization which designate Mr. Dillahunt as manager. So that would give him the ability to bind the LLC.
Okay.
Is that?
Yeah. I just wanted to confirm that hear that from you. I think, did everybody get the information that she's talking about, the purchase lease and information about Mr. Dillahunt's authority? Okay.
Okay.
We now have it on record. We're okay.
Okay, very good. Thank
Okay.
you.
With regard to step 2 about the application is complete, is there anyone from the audience that would like to speak in favor of the application or opposed to the application with regard to its completeness? Seeing no one, we'll move on to step number 3, requirement number 3. If completed as proposed in the application, the development will comply with all the requirements of the ordinance. And the applicant, again, is offered the opportunity to speak on behalf of that requirement.
Yeah. We believe, I think, that staff has already found that the site plan submitted in the application has met the requirements. In particular, that the setback, that the site plan meets the setback requirements as well as the site plan requirements in the ordinance, and the applicant will adhere to the screening requirements, which is the type A buffer.
Okay. At this time, the public will have an opportunity to comment if they so choose. Anyone that would like to speak in favor of or opposed to item number 3, that the proposed, if it's completed as proposed, the development will comply with all the requirements of the ordinance. Seeing no one addressing to the podium, we will move on to requirement number 4. The use will not materially endanger the public health or safety if located where proposed and developed according to the plan as submitted. The applicant had the opportunity to address that particular requirement.
Thank you. Good evening, Chairman, members of the board. My name is Chris Sandifer. A little bit of an introduction earlier. I am a graduate electrical engineer from Clemson University, 1975. I have been a practicing electrical engineer since that time. I'm a registered professional engineer in multiple states, including North Carolina. I also have a electrical contractor's license in North Carolina with the unlimited classification, and I personally own 100 acres that are currently under panels right now that are on family-owned farm that are actually in generation since 2015. I serve on the Nash County Planning Board, and we've approved 37 utility scale solar farms to date, and we find them to be very advantageous to our county. I'd like to start saying that for the health and safety aspect, there's over 3 gigawatts, 3,000 megawatts. This is a 5 megawatt project. There's already 3,000 megawatts in production in North Carolina now. This project is very much similar to those projects. It doesn't differentiate hardly at all. So the technology is old. I say that because we use galvanized steel pressed into the ground with hydraulic presses, so it's not going to, we'll try to minimize the grading if any is needed. And onto those steel structures, those piles that are driven in the ground, we'll put racking, which would actually rotate. It's going to track the sun. It starts in the east and moves very slowly, but it tracks the sun. And to maximize the energy production from this facility. Attached to those racks would be the first solar panels that are actually made in the United States. They have been ordered or purchased. I'm not exactly sure where we are in that process, but they will be American-made panels. The first solar is a recycle center, so any panels that are broken or damaged in construction, they can be sent back and they can be recycled. They're doing that now. There's nothing hazardous about the panels. They're basically a substrate that are covered with glass. It's a thin film substrate that's got glass on the top and the bottom, and then they're encapsulated with aluminum frames. And those frames are mounted to those racks. Output of that panel is DC current, like a battery. At DC current, they put a string of panels together. They run into an inverter. That inverter is an electronic device that's been around since the 60s, just like the panels have been around since the 60s. And it converts that from a DC current to an AC current, which is what is used to light this building, is what the utility will purchase. The output of that inverter goes to a transformer, which matches the voltage of the output of the inverter to the utility voltage out there on NC55. And so there's nothing new about it. Before construction starts, there would be a 6-foot fence put up all around the project area, and that's in accordance with the North Carolina Utilities Commission and National Electric Safety Code, and it will be in place and locked if there's nobody there, if there's no personnel on site until the site is removed, until the equipment is removed. Let me see. I was going to mention that there will be internal road provided in accordance with the plans. There will be a DOT driveway permit, we'll have to get that done and approved before construction. That's part of the permitting process. There will be a sediment erosion control plan approved by the North Carolina Department of Environmental Quality, and that, once again, that would have to be approved before construction would start. All the components VUL listed and labeled. All the construction will be in compliance with the the NEC, the National Electric Code, as well as the North Carolina Building Code. And I was asked to comment a couple of things that no studies that I'm aware of, and I've looked for them. I've been doing this for 10 years, just interconnection and solar farm. have been forthcoming to indicate there been any negative impact on any kind of wildlife. And I also row crop. Among some of my other jobs, I still do farm. Although I have 100 acres on the panel, I still have part of it that I do farm. And although I won't probably be alive when this facility is decommissioned, I fully intend that it go back into a row crop farming, and there's nothing being put on the ground, in the ground, around it that would negatively impact this farm going back to an agricultural row crop use, or if you want to put it in wood fiber or whatever you want to do. And so, or my son or my grandson or whoever's going to be alive when that time comes. So I just want to state unequivocally and without hesitation that this project put in the way these plans specify will not materially impact the citizens of Craven County.
Thank you very much.
Any questions?
Is there anyone in the audience that would like to speak in favor of or in opposition to the request for the solar farm with regards to endangering the public health and safety? Any questions from the board? From Sanford? How long does the solar farm, what is the life expectancy of a solar farm, and what happens to the solar panels at the end?
Right. Well, I have performed a lot of decommission reports because that is something sometimes that a panel would want a commission or engineer to seal those reports. So basically, these panels have a 25-year warranty. That's not to say it's 25 years, one day they go bad, but they are warranted for 25 years. So certainly they would be expected to last that long. The transformers, inverters, the wiring, the other infrastructure is put in, typically that's a 40-year life. And of course, the fence, the concrete, or whatever, I mean, that could be, I don't know how long that could last. It maybe probably depending on the weather and stuff, but 50 or 75 years would be the life on that. So the most critical component would be the panels. But at the end of 25 years, you could always take those panels out, recycle them, and put in new panels if you wanted to. I mean, the output of those panels continue to go up. When I started this business, if you could get a 200-watt panel, wow, that was really, really good. Now they're 450, nobody even thinks about it. I mean, they're over twice what the output. So if 10 years from now they keep going, at some point in time it may be worth it to the applicant or, the plot hound to actually repanel it just to get more energy out of it. I don't know that would happen. They wouldn't have to do it. But I would say the typical leases I've been involved with are around 40 years. That's when the initial lease is 40 years. So I'm thinking that developers are thinking 40-year time frame is what they're shooting at.
Thank you. And then follow-up question, the land lease with Mr. Dillahunt, what is the duration of that?
Yeah, I can answer that question. So it's a 30-year lease with the option to extend up to 45 years.
Okay.
And potentially, I mean, it could extend beyond that if the parties, so agree to it.
Okay.
Question. I'd like to know what the height of the racks are.
It's in the plans. Typically, the bottom part of the panel would be about 3 feet off the ground, but they can be lower or they can be higher. But typically, they rotate, and so the panels at the top when it's most vertical, either late in the evening or early in the morning, you're looking probably 9.5, 10 feet. What does it say? How much? Okay. 9.5. 90 inches is what you're saying. So that's less than 8 feet. So these panels are shorter. Most times, sometimes they double panels on those racks, and these are only single panels. So the maximum height on this one is 90 inches, which is less than 8 feet. So it's about 7.5 feet.
Thank you.
Any other questions?
Yes, I have a question. Yeah, I noticed you said that you all going to be involved with Duke Energy, going to be involved with this solar project.
Yes.
So that means that the customer will be saving more money, right?
That's the hope. So we know we can't guarantee that it will lower power prices in the area, but the hope is that we are providing a cheap source of energy to the grid, and that in theory could help reduce the power prices in the area.
Thank you.
Any other questions before we move on? Okay, let's look at requirement number 5. The use will not substantially reduce the value of adjoining or abutting property. And this is a two-part question. The second part is, or that the use is a public necessity. And I think we'll deal with those separately. And we'll deal first with the values of adjoining properties. Mr. Kirkland?
Good evening. Yes, my name is Rich Kirkland. I'm a state certified appraiser. I'm also an MAI through the Appraisal Institute. I've been appraising across North Carolina for about 25 years now, looking at a lot of farmland. I do a lot of agricultural uses, residential subdivisions, and commercial properties. I was asked to look at this for an impact analysis on the solar panels. I'm sorry, my glasses are constantly clogging.
I have the same problem.
But I've been looking at this question for a little over 9 years now. I've looked at, in that time, I've looked at almost 700 solar farms. Most of that's in the state of North Carolina, but I've also looked at about 17 states overall. I believe you got a copy of my impact analysis, and it shows what's called batch pair analysis or impaired sales analysis. This is how you address whether or not there would be an impact on adjoining property values. Is you look at sales of homes and farmland next to a solar farm to see if it had any impact on that property value or that sales price. There's 24 home sales that I've looked at in the report, and there's also 7 land sales that I looked at, and just compared them to other sales of similar homes nearby that are just not next to a solar farm to see if there's any impact. Consistently finding no impact on property value. I'm finding that to be true whether I'm looking in eastern North Carolina, the Piedmont, the mountains, or roughly 16 other states. Essentially, it's a passive use. It's quiet. It's typically got good setbacks and landscape screening between adjoining residential uses, and it's just a very harmonious use of that property. It's just a different way of accessing it. But one of the comments I get from folks who do live next to solar farms, because I've also interviewed folks living there and asking about what their experience has been like, and a lot of folks are saying, well, it's a lot better than having a lot of houses behind us. If there was going to be a subdivision back here, we'd have a lot of neighbors, dogs, and noise, and again, at night, there'd be a lot of light pollution back there. The solar farm, it's just still going to be dark. So it's my professional opinion that this is going to provide no negative impact or consequence on the adjoining properties. That's harmonious use. I could go into a lot more detail or if you need that, but I believe you got a copy of the report, and I'm happy to answer any questions.
Well, after we hear from the public, the board might have some questions for you. We'll call you back. Is that okay? Yeah, the second half of that question is that the use is a public necessity. You did mention in your presentation that you have a certificate of need from the state of North Carolina. Would you like to address that?
Yeah, absolutely. So the proposed solar farm was granted, it's called a CPCN, so it's a Certificate of Public Convenience and Necessity, and that was granted by the NCUC, which is the North Carolina Utilities Commission, on August 21st, 2018. The CPCN is granted to an applicant only if the applicant is able to show that public convenience and necessity defined by the state requires such construction. So we were granted this permit, like I said, in 2018. So that allows us to develop and then construct the solar farm. And this CPCN was included in our application packet.
Thank you. Is there anyone in the public that would like to make a comment regarding opposition or in favor of the 5th requirement about the values of adjoining properties? If not, I'll ask the board if they have questions regarding that topic.
Yes, in regard to quiet, what actually is the decibel? Have we have a decibel measurement for the noise?
A little hard to hear, and I can't reach your lips, so it's a little bit of disadvantage, but I understand you've got a question about the noise.
The noise level.
Right. this type of project, at the boundary project, the noise would be indistinguishable from the background noise. At night, it produces no noise. So if somebody's trying to sleep, it's not gonna bother, but it is, it would be, like I say, you can hear it from the, you could not hear it at the fence line.
Thank you.
I guess to follow on Althea's question, so your output your ultimate output transformer won't have a loud hum to it or anything like that. It'll just it's a rather static transformer.
It would be almost exactly the same kind of transformer that's serving this building. And you probably walked by it a bunch of times and never heard it. And so if you hear the transformer or someone hears it, that means there's a problem. If the transformer should not make any noise, it doesn't hum, but you can't hear it, 50 feet away. But I know some transformers make noise, but that's because they got loose lamination in them, and the transformer is defective, and it can be replaced.
Understood.
Just to kind of follow up on Mr. Stanford's statement, the transformers that we have contemplated for the site, so there are 3, they will all be located on the interior of the site, so a substantial distance away from the fence line. So,
Any additional questions from the board? Okay. Requirement number 6, the location and character of the use, if developed according to the plan submitted and approved, will be in harmony with the area in which it is to be located and in general conformity with the plan of development of the city.
I guess I can address part of that. I know I said before that I found it in harmony, but part of how I quantify that is, again, you can see in the report, all these 680 solar farms I've looked at so far, I always identify all the uses around it, looking at what's around solar farms. In North Carolina, over 90% of the adjoining uses are agricultural and residential. When I look at it based on the number of acres, the most common adjoining use is agricultural. If I look at it based on the number of parcels, the most common adjoining use is residential. They're really being located in those areas where agricultural, residential uses are in proximity, because you need the open space for the panels to be put in, but you also need to have infrastructure to pull the power out and nearby users to use that power. So this is a very typical location across the state. You can see throughout that these are the types of locations where they're being located. And as far as what was the second part of the question, as far as the harmony of use and
Conformity with the plan of development of the city.
that, I'm going to let Christine.
yeah. So I think as Rich said, the surrounding properties currently are being utilized for agricultural and rural residential. We believe that the project would be consistent with the land use pattern that exists today. Per the New Bern Cama Regional Land Use Plan, I believe these properties fall what is into the urban transition use. And so we believe our proposed use will be in conformity with that. It'll maintain that open tracts of land to ensure there's no overdevelopment, and will not generate any kind of like noxious fumes or odors or create any increased traffic in the area.
An opportunity for anyone in the audience, if they'd like to comment in favor of or opposing the question about the general conformity with the plan of development and in harmony with the area. Seeing no one approach the podium, we will turn this over to the board. Any questions about that particular topic for the applicant? Seth, are there other solar panel farms within the confines of the city limits?
I believe from conversation that there is 1 or 2, but I'm not familiar with exactly where those are.
There's another one on 55.
On 55, that's what I was thinking, so.
That was 2015, I believe.
All righty. This is a final opportunity for anybody in the audience to make any comments with regard to the application for the special use permit. If not, I'll turn to the board and request a motion to close the public comment period.
So moved.
I second that.
We have a motion and a second to close the public comment period of this proceeding. All in favor signify by saying aye.
Aye.
Opposed? Motion carries. Okay, now it's time for the board to go through the same 6 steps and have conversation internal to the board, thoughts, comments after hearing the presentations and the evidence that's been presented by the applicant. Again, the first requirement is that the requested permit is within the jurisdiction according to the table of permitted uses. Board, any thoughts, comments?
I can confirm it's in the correct category, and Mr. Chairman, I move that we find the requested permit is within the jurisdiction according to the table of permitted uses, permissible uses.
I second that.
Okay, we have a motion and a second. Any comment, thought, questions from the board before we vote? Seth, this will take a roll call vote, so will you please call the roll?
Yes, sir. Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Paraboy,
Yes.
Barbara Sampson,
Yes.
and Ross Beebe.
Yes.
Alrighty, move on to number 2. The application is complete. Questions, comments from the board, discussion?
Just a clarification, I guess, because the drawing was very difficult to read detail when I zoomed in. But the type A screen will be all vegetative? Or will the screen be a combination of fence or berm? Is it all vegetative for the type A screen?
It will be a combination of planted and existing.
And what?
Planted vegetation and then existing.
Existing, okay.
Yes.
And so the fence that you referred to is removed after construction, is that correct?
No, the fence will stay in place.
The fence stays?
Yes.
Okay.
Yep. So 6-foot-high fence, just a chain link fence, and that's to meet the NEC as well as insurance.
Okay, thank you.
You're welcome.
I do believe that on the side of Mr. Tyler's property, there's a fairly heavily forested strip of land there. It'd, probably be left for natural screening. Okay. Any other questions, comments for the applicant regarding item number 2? That board, the chair will entertain a motion.
Mr. Chairman, in taking consideration of clarifications as presented tonight and the clarifications recently submitted, I would move that the application is complete as submitted.
Okay,
Second.
We have a motion and a second. Is there any further discussion regarding item number 2? If not, Seth, call the roll.
Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Paraboy,
Yes.
Barbara Sampson,
Yes.
Ross Beebe.
Yes.
Motion passed.
Yep. Item number 3, if completed as proposed in the application, the development will comply with all the requirements of this ordinance. Turn that over to the board for questions, comments, discussion.
No.
Hearing none, board would entertain a motion.
Mr. Chairman, I move that if completed as proposed in the application, the development will comply with all of the requirements of this ordinance.
Second.
Have a motion and a second. Any additional discussion? If not, call the roll, please.
Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Paraboy,
Yes.
Barbara Sampson,
Yes.
and Ross Beatty.
Yes.
Motion passes.
Requirement number 4, the use will not materially endanger the public health or safety if located where proposed and developed according to the plan as submitted. Board may offer comments, discussion, questions.
I believe the expert testimony satisfies this. And I move that the use will not materially endanger the public health or safety if located where proposed and developed according to the plan as submitted and approved.
I second that motion.
We have a motion and a second. Any further discussion amongst the board? If not, we'll have a roll call.
Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Paraboy,
Yes.
Barbara Sampson,
Yes.
Ross Beatty.
Yes.
Motion passes.
Item number 5, use will not substantially reduce the value of adjoining or abutting property or that the use is a public necessity. We normally address this as 2 separate issues, and the city attorney likes to have both of them clarified in the minute. So let's deal right now with the matter that it will not substantially reduce the value of adjoining or abutting property.
Mr. Chairman, based upon expert testimony we have received tonight, I move that we find that it will not reduce the values of adjoining properties.
Get a clarification first. Seth, do you have his analysis? Because we don't have a copy of that.
Yes, sir. I apologize for not including that. I do have,
So that's part of the record too.
that's part of what they have included in the record.
The record.
I second the motion.
Any further discussion regarding the substantial reduction of value on adjoining property? If not, call the roll.
Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Paraboy,
Yes.
Barbara Sampson,
Yes.
and Ross Beatty.
Yes.
Motion passes.
Okay. The second part of that requirement is that the use is a public necessity, and normally if there's no adjacent values reflected or in conflict, we don't have to deal with that. But again, for the record, I think it's fair to say, based on the testimony and the fact that there is a certificate of necessity has been issued, that we might go on record also saying that the solar farm has been recognized as a public necessity. Do we have a motion to that?
We do, Mr. Chairman. I move that as a result of having the certificate of public need in the record, that we can find that it is a public necessity for this project.
Okay.
Second.
Have a motion and a second. Further discussion or questions? Call the roll.
Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Paraboy,
Yes.
Barbara Sampson,
Yes.
Ross Beatty.
Yes.
Motion passes.
The final condition, that the location and character of the use, if developed according to the plan submitted and approved, will be in harmony with the area in which it is to be located and in general conformity with the plan of development of the city. Board discussion? Questions?
Well, the fact that it is in the table of permitted uses establishes the fact that it is in harmony. And I've heard no testimony to refute that. So, Mr. Chairman, I move that the location and character of the use, if developed according to the plan submitted and approved, will be in harmony with the area in which it is to be located and in general conformity with the plan of development of the city.
Second.
Have a motion and a second. Any discussion? Call the roll.
Barbara Sampson, Dorothea White,
Yes.
Peter Dillon,
Yes?
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Perigore,
Yes.
Barbara Sampson,
Yes.
Ross Beaton.
Yes.
Motion passes.
Okay. We've been through the 6 requirements, and they've been affirmed in all cases, so it's up to the board now to make a final resolution to approve the special use permit for the solar farm.
Mr. Chairman, I move we approve the special use permit for the solar farm, and I find no conditions.
Okay?
Second that.
Okay, we have a motion and a second to approve the application as submitted with no conditions to be added. Any further comment, questions from the board? Roll call?
Dorothea White,
Yes.
Peter Dillon,
Yes.
Jim Morrison,
Yes.
John Riggs,
Yes.
Kip Perigore,
Yes.
Barbara Sampson,
Yes.
Ross Beaton.
Yes.
Motion is approved.
Yep, yeah, it's all done. You have a special use permit coming your way.
And I've
When-
got those up there for you to sign if you.
Yeah, I know.
When would you expect to start?
Rather soon, actually, I think within the next month.
Great,
looking to
great,
start.
okay.
Yeah. As Mr. Sandifer stated, we have panels ordered, and then Duke has actually already started working on their side of the facilities. So just doing all the system upgrades in the area, and then working on the interconnect.
Thank you.
So we're good. That's it.
If you'll bear with us for another minute or two, I'll sign your special use permit and
Yeah, absolutely.
be on your way. The last item that I wanted to discuss with the board is you all received a new outline for the board that was approved by the Board of Aldermen back in the spring, but that reduces the size of the board. And this was not any of our actions. This was done by the Board of Aldermen, and the consequences you see listed here, that we now have a 7-member board, and those that will be no longer with us are those whose term expired in July, come the 1st of July. And that leaves the residual board that you see listed here with all the contact information. So I just wanted to make sure that everybody understood what was going on there. This is a change that we were told to do.
As I recall, we previously discussed that a few months ago, hadn't we?
Yeah, the board looked at it as a similar size Board of Adjustment in other cities, and also the fact that I think what really inspired this review of the board size and so forth was the lack of a quorum at several meetings during the last year that put the applicant in a bind, so to speak, since we couldn't act officially. So,
And they did reduce the quorum from 8 to 5.
yes. So, just like I say, that's just a bit of information. Wanted to make sure everybody was up to date on that and had that information. That being completed, I'll entertain a motion to adjourn unless there's additional information from the board that we'd like to discuss. Dorothea?
At this time, I would just like to tell the board that it's been a pleasure to work with you all. My time does expire tomorrow. So thank you so much for this opportunity, and Mr. Perigore, it's been a pleasure.
Well, just to let you know, Dorothea and I served together on the Planning and Zoning Board, and then again here, and it is, it's always refreshing on a board like this to have someone who does their work and is involved and asks the questions that need to get asked. She's been a real asset on every board she's ever served on that I've been a part of also, and I do appreciate it, and appreciate your time serving the city over the years.
Thank you very much.
Thank you. Is there a motion to adjourn?
I make a motion to adjourn.
Second.
Motion is second. All in favor signify by saying aye.
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 We're done for the month of June.